Hello, I'm Veronica Roberts and I lead our global foreign direct investment group at Herbert Freehills. And together with my colleagues, Ruth and Ali MACGREGOR, we are honoured that our article on trends in global foreign direct investment regulation has been selected as the winning article in the Business Cross-Border Issues category at this year's Antitrust Writing Awards. Thank you to the jury and also to everyone who voted for our article. Stricter enforcement and enhanced scrutiny by foreign direct investment agencies around the world mean it's more important than ever before that deal parties think about the FDI issues at the outset. Are there any issues? How can they be navigated? And in the worst case scenario, could they prove problematic for your transaction? So we're delighted that our article on global trends and how to get the deal through those processes has won at this year's awards. We'd like to say thank you to all of our colleagues in our global FDI network who are specialists in their own jurisdictions and gave us a lot of invaluable tips and guidance when we were preparing this article.
Picking up briefly on some of the key global trends highlighted in our article, it's now clear that the concept of national security as the main public interest justification for state intervention in foreign investment continues to evolve. It's much broader than just military or defence interests, with transactions in a wide range of sectors now potentially at risk of review. We're also seeing a widening focus beyond just Chinese investment, with the combined impact of the COVID-19 pandemic and heightened geopolitical tensions resulting in a swathe of changes to FDI regimes around the world, aimed at enhancing scrutiny and stricter enforcement of the rules. So, for example, we're seeing increased use of mandatory notification requirements, lowering of notification thresholds, and increased powers to impose sanctions for non-compliance.
Our article highlights various examples of each of these global trends in practice, but it also has a real focus on practical guidance for investors when navigating this increasingly fluid and uncertain regulatory environment. We set out a number of ways in which deal risk can be minimised, both in terms of anticipating potential objections from the outset and engaging proactively and sensitively with the process of securing political support and considering potential remedies up front where national security concerns are likely to arise. We also highlight some practical considerations, such as the impact of notification and standstill obligations on the deal timetable, the allocation of risk within the sale and purchase agreement, payment of filing fees, which are becoming increasingly common, and the importance of a global and coordinated approach to securing clearances where required.